agreeing to join us on a very short notice. We transmitted to them a list of questions on emerging issues that we would like to discuss for today. But before we get to those 5 questions, we had invited them to provide first opening remarks if they wish to. We understand that most of them do not want to give initial remarks, but that Commissioner Sarmiento did prepare a short presentation for all of us today. So unless anyone else would like to begin, then may I call on Commissioner Sarmiento to present.
Negotiating with the NPA and NPF for many years. Our Justice Carpio Morales, our 2 professors from the UP College of Law, Professor Gwen, Professor Ted, my colleague in the Free Legal Assistance Group, my co-panelist of the second panel, and of course our beloved Dean of the UP College of Law, Dean Darlene. She's the darling of the College of Law. To the students of law, to lawyers, representatives of the House and the Senate, Senator Robin Padilla, guests, ladies and gentlemen. May I go direct to the point? In the ongoing national conversation on impeachment, 3 issues emerged. And what are these? Number 1, can the Senate of the 20th Congress continue the impeachment trial that has started during the Senate of the 19th Congress? Number 2, can the Senate forthwith proceed with the impeachment trial even during recess? And number 3, can the President call a special session at any time? My answer to issue number 1 is yes. This has been addressed in the case of Pimentel Jr. versus Joint Congress Committee to canvass the votes for the President and Vice President, a 2004 decision, where our beloved Justice Carpio penned her separate concurring opinion. Petitioner Aquilino Pimentel Jr. asked the Supreme Court to annul the proceedings before the JCC because it has become functus officio because of the new Congress. But petition was denied by the Supreme Court in an en banc resolution. The Supreme Court making a distinction between legislative function and non-legislative function. The Supreme Court saying that it has not become a functus officio insofar as non-legislative function. Meaning outside of legislation, it has a continuing function. It could be convening as a canvassing board. It could even be serving as an impeachment court. And a separate concurring opinion, our esteemed Justice Carpio Morales, citing the extensive deliberations in the 1986 Constitutional Commission, in the exchanges between Commissioner Maambong, a former lawmaker, and Commissioner Davide, a former lawmaker. She wrote that again, repeating the legislative and non-legislative function of Congress. So yes, it has been functus officio insofar as performing its legislative functions, but not its non-legislative function, which is continuing. My answer to issue number 2 is yes. Can the Senate forthwith proceed with the impeachment trial? Ito po ang mainit na pinag-uusapan po ngayon sa ating lipunan. Further proceed, or in the Tagalog version of the 87 Constitution, dapat agad isunod, is a novel addition in the 1987 Constitution on impeachment, not found in the 1935, not found in the 1973 Constitutions, not even in the U.S. 1787 Constitution. In ordinary meaning, as constitutionally interpreted, it means right away. It means immediately. Walang patumpik-tumpik. Walang alinlangan. Gawin kaagad. The records of the 1986 Constitutional Commission. Walang alinlangan. Gawin kaagad. The records of the 1986 Constitutional Commission are bare. When forthwith proceed was introduced, it was part of the committee report number 17 on accountability of public officers and submitted for plenary discussion on July 26, 1986. Yours truly was the acting floor leader when this committee report, which includes forthwith proceed, was presented on the floor. Absent discussion on forthwith proceed, its immediacy and urgency can be drawn from the intent of the framers of the Constitution, from the exchanges of the members of that commission on the time-compelling significance of impeachment. Commissioner Regalado Maambong, citing, quote, power of impeachment guide to Congress, said that impeachment is not personal punishment or vendetta, but primarily to maintain constitutional government. The President is called to account for abusing powers which only he possesses that have a tendency to subvert constitutional government. And it would include other impeachable officers. Commissioner Blas Ople, in his poetic language, his usual poetic ornate language, stated that impeachment is a sword in the scabbard. It is as good as a sword drawn. It is not a constitutional decoration or a tinsel, but a powerful check on the presidency. The prospect of an impeachment trial, according to him, caused then U.S. President Richard Nixon to resign. Commissioner Felicitas Aquino inputted that impeachment is in the nature of an exemplary act by which the state infuses the highest sense of responsibility to public service. Finally, Christian Monson said that it is a deterrent and added that President Marcos Sr. exerted all efforts at that time to defeat the impeachment proceeding and the subsequent calling of a snap election at the time may have been influenced to some extent by an attempt at impeaching him. We go to question number 3. Question number 3 is, can the President at any time call a special session? My answer to issue number 3 is yes, is also yes. The President may at any time call a special session of Congress. The 1973 Constitution says the Prime Minister may call the National Assembly to session at any time, quote, to consider such subjects or legislation as he may designate. The 1987 Constitution provides that, quote, the President may call a special session at any time. The Philippine experience is that President Elpidio Quirino and President Gloria Macapagal Arroyo, in separate proclamations, called a special session of Congress. Quirino called for a special session to address insurance loss concerns in the Philippines. President GMA to address the VAT issue at the time. In the US, the President has called a special session of Congress to tackle issues related to war, economic crisis, ratification of treaties, and others. It's more broad in the US. The President calls for a special session. May President BBM, our wish, call a special session of the Senate to start the impeachment trial. Of the three issues, the first best option to me, is forthwith proceed. Reasons were already given. The second best is a special session. And the third best is the new Congress continuing the impeachment trial if it is not done before Congress adjourns on June 13, 2025. In the light of these intractable emerging issues, I humbly suggest a National Day of Prayer to beseech God Almighty for guidance and wisdom. Benjamin Franklin introduced the idea of prayer in the sessions of the 1787 Constitutional Convention, realizing the importance of prayer, God's powerful role in the life of nations, in shaping their destinies. The same reason why George Washington, in his oath-taking as the first president of the United States, added in the presidential oath, "So help me God." And thereafter, future presidents all over the world included "So help me God" and their swearing-in ceremonies. Well, this may be difficult times in our country. The impasse on this issue of impeachment impacts our country politically and economically. The soonest this issue is put to rest by a wise and bold choice of any of the options I have mentioned, the better for our country to become wiser, stronger, and God-praising. Yes, the worst of times can be the best of times. Maraming salamat po.
Thank you, Commissioner Sarmiento. The 5 questions we presented to our panelists via email are actually the following. First, may the Senate hold the impeachment trial even if Congress is on recess? And can the President call a special session? The second is, may the impeachment trial carry over from the 19th Congress that impeached the Vice President to the 20th Congress? The third would be, would the Vice President's resignation result in the cancellation or pre-termination of the impeachment trial? The fourth is there a standard of evidence in impeachment trials, or should there be? And the fifth is, if a case is brought to raise these questions, may the Supreme Court step in, and more importantly, should it? So we hope to discuss all of these 5 important questions in the short time that we have. And so let me begin immediately with the first question, and may the Senate hold the impeachment trial even if Congress is on recess? We heard from Commissioner Sarmiento
who talked about the difference between legislative and non-legislative functions. I wanted to ask first for the rest of the panel what their thoughts would be on this. Senator Dulon would be a very interesting reference because of his experience in the Senate.
Thank you very much. Yes, I have been a senator judge twice in my life already. But anyway, first of all, let me greet a colleague in the Senate, Senator Robin Padilla, who will be a senator judge come and what's impeachment trial. So the first question is, can the president, can an impeachment trial take place during the recess?
Yes.
Okay. The answer is the impeachment court can only be constituted in a proper referral when the Senate is in session. If the Senate is not in session as it is today, this impeachment court cannot constitute itself because the reference of the impeachment complaint is to the Senate. And therefore, the Senate, in a formal session, will refer this to the impeachment court. So the impeachment court has to be created upon a session of the Senate. Can the president call a special session? Yes, the power of the president to call a special session is not limited by anything. If it is the theory that the impeachment, the president can even call a special session so that the impeachment trial can take place. And if the president can call a special session to consider legislative measures, even the renaming of a street is a legislative measure which we can taken up in a special session. How much more an impeachment trial? In my view, an impeachment trial can be called by the president in a special session. What's the next question?
I think we can stick to the first question first, Senator.
Okay. Thank you very much.
Thank you, Senator. Justice Carpio Morales, your thoughts.
The Senate is in recess with respect to its legislative functions. Impeachment is not a legislative function of Congress. The impeachment provisions fall under the accountability provisions of the Supreme Court and not under the legislative department provisions of the Supreme Court. So, given that, I believe that impeachment cannot be constituted during recess. This does not mean that during recess, the Senate cannot call for special session. But this is prescribed by so many limitations, including only on urgent legislative matters, and given that, among others, and given that impeachment is not included as among the reasons why special session can be conducted, my conclusion is that no, impeachment proceedings or this impeachment trial cannot be conducted during recess. Thank you.
Thank you, Justice Carpio Morales. May we hear from Prof. De Vera and then Prof. Te first.
Thank you, Prof. Tomase, and thank you to our co-panelists for this afternoon. I tend to agree with the view that's already been presented, that while the Senate is in recess, they will not be able to constitute themselves into the impeachment court. However, there's another question that perhaps we can discuss in the second round, which is, are there preparatory steps that may be undertaken while the Senate is in recess, so that if they do decide immediately upon resumption of session on June 2 to constitute themselves into an impeachment court, then trial can proceed forthwith. Noting that in the two previous impeachment trials, of course we can ask our Senate President here, shortly after the transmittal of the articles of impeachment, I think within a few days, the impeachment court was constituted and subsequently trial ensued. Thank you.
Prof. Te?
Thank you. Yes, I share well, what is now apparently a consensus that the Senate cannot hold the trial during the recess, simply because when the articles were transmitted, the Senate had already gone on recess without taking steps to convene the Senate as a court to draft up the rules of impeachment, even if they were simply to adopt the previous rules of impeachment that had been used by the Senate before. And so, yes, I would share that consensus, but I also agree with Professor Gwen that during this break, during this recess, the question of whether the Senate can take certain preparatory steps towards making the trial, any trial that may happen once the recess ends, perhaps more expeditious. Whether that could happen, I think that is not foreclosed as far as the Senate is concerned.
Thank you, Professor. So if I can ask our Senator Drilon or Justice Carpio Morales or our colleagues in the faculty here, there is, however, this view from other academics, other scholars who think that delaying the impeachment to when session resumes in June 2 might frustrate both the word forthwith in the Constitution and also principles of accountability. And I think I was in a conversation with Justice Vivi Mendoza on this, where he says that the great battlefield of constitutional law today is the meaning of the word, or is the word forthwith. So I wonder what your thoughts would be in relation to that. Would delaying impeachment actually result in frustrating accountability?
You know, to resolve that question, I have asked the President to call a special session. Even if you don't include as an item in the special session the impeachment trial, the Constitution provides that the Senate that the impeachment trial shall take place forthwith in the Senate. So even when as a reality, when the President calls the Senate into a special session, the first item on the agenda is consideration of the impeachment complaint filed by the House. And that will be referred to the impeachment court. And then you start the impeachment trial. So I strongly believe that when the President calls for a special session, the impeachment trial immediately takes place because of the mandate of the Constitution.
Thank you, Senator Drilon. Justice Carpio Morales?
According to Black Dictionary, forthwith means immediately, at once, but it also considers reasonable delay.
Some of the senators, current senators, are running for re-election. To me, these constitute circumstances that can abate the use of the word forthwith. Thank you.
Thank you, Justice. Prof. Gwen, Prof. Te.
Thank you, Justice. My understanding of the word forthwith used in the Constitution is not just immediately, but also a sense, as Justice Carpio Morales pointed out, reasonableness, that it means avoidance, undue delay. So that if the action of the Senate is not animated or motivated by imposing undue delay in commencing the proceedings, I think they would well be in compliance with the constitutional mandate to proceed with the impeachment trial forthwith.
Thank you. Prof. Te.
As litigators would know, often when you go before a court and ask for time, the court will usually ask you if you're trying to delay the proceedings. So the question of forthwith, I think, also goes into motivation or intent or things that you can foresee or cannot foresee. So I would agree with Justice Carpio Morales that while it would mean by ordinary meaning, immediately, but it also takes into account circumstances. It also takes into account reason, and it takes into account things that the Senate cannot control, like the recess. The objective circumstances being that the transmittal was made on the last day of the session, and they had gone into recess before they had referred it to the impeachment court. Therefore, that may constitute, even though there is a span of time that intervenes, that may constitute reasonable delay, as it were, and would not frustrate the meaning of the word forthwith.
Commissioner Sarmiento, I'd like to ask if you have a response to these views.
I see the wisdom of the responses of Senator Frank, Justice Carpio, and my co-panelists. But I mentioned in my presentation, this is a very novel addition in our history as a people, not even found in previous constitutions and many constitutions of the world. Very unique provision in the Constitution. Traditionally, yes, on recess cannot be, unless the President calls for a special session. But this is a novel addition in the Constitution. And in the light of the intention of the framers of the Constitution, na walang patumpik-tumpik, umpisan kaagad. Because it's a time-compelling, significant activity in our country. Accountability, checking abuse of powers, etc., etc. Then, to me, I would say that regardless of the recess, a time impeachment trial should begin in the light of this constitutional provision.
Yeah. I cannot accept the proposition that simply because the senators will be campaigning such an important and critical constitutional duty to constitute itself as an impeachment court and try the impeachment complaint can be deferred. Firstly, the Constitution says shall be tried forthwith. And we give ordinary meaning to ordinary words. Forthwith means immediately. And it is my respectful submission that the campaign period is not a valid reason to postpone. And in fact, there should be no circumstance to justify a deferment because the Constitution mandates the performance of a constitutional duty forthwith. The only reason why we need a special session is the formal referral of the impeachment complaint to the impeachment court.
Thank you, Senator.
Mr. Tamase, may I make a follow-up? We have in constitutional law the doctrine of constitutional supremacy. All laws, all regulations, all contracts have to yield to the supremacy of the Constitution. I think all lawyers would know that doctrine. So if recess is a legal provision, it is a provision in the rules of the Senate. They have to yield to the command of the Constitution about forthwith proceed.
Thank you, Commissioner Sarmiento. I understand it may have also been in line with the innovations in the 1987 Constitution to make
to preserve constitutional government, to preserve the order in our country, to avoid chaos. So to me, the lowering is very relevant to this forthwith proceed provision in the Constitution.
Thank you, Commissioner Sarmiento. I think the reason why, Justice, thank you. Would you have a response to this question? I think the points of Commissioner Sarmiento. Thank you, Justice.
I'm going to respond to the fact that, the Hello Garci case. Hello Garci, I'm sorry. The Supreme Court said that the Senate is a continuing body. It's a continuing institution. But the discharge of its day-to-day normal functions, it is independent of the predecessor. In other words, it's not bound by what the preceding Congress, Senate, did. So any unfinished matter can be considered as if it's set for the first time. Thank you.
Thank you, Justice Chit. I think that brings us to the second question, which ties into the urgency of the impeachment or the sense that the Senate should proceed immediately. Can you please flash the next question? So the second question, and I think it ties into this concern that if the Senate does not meet now, when it is on recess, then there might be a frustration of the impeachment trial, because another question that keeps coming up is that will the impeachment trial carry over from the 19th Congress to the 20th Congress, when I think I understand from Garciliano and the older case of Arnott, the Supreme Court said that the Senate is a continuing body, but then we have this more recent case of Balag where the Supreme Court now says that Congress or the Senate's business does not continue beyond a Congress. So your thoughts, Justice Carpio Morales or Senate President Drilon, on this?
Well, I'm not the Supreme Court, but I maintain my position.
Thank you, Justice. Senate President Drilon.
To me, this is an open question. Can the impeachment complaint filed in the previous Congress be continued when the new Congress comes in and the new impeachment court comes in? A lot of questions have heretofore been not answered. Yes, there is a view that the Senate is a continuing body and therefore can continue to hear the impeachment complaint. You know, there are a lot of opposite arguments can be raised, as in this is not in the nature of a investigation by Congress, but you know it's an investigation of the impeachable offenses allegedly committed by the Vice President, and therefore the question is, can the question of the mandate of the present Congress when it expires, etc. So this is an issue which I don't pretend to be able to answer right off the bat, and maybe the colleagues of Chit here in the Supreme Court can answer that question better. But it is a question which has not been answered, and that is why I hope that this can be raised so that for us to be enlightened.
Commissioner Sarmiento, would you have a response to this question?
Professor Tamas, so far as that question is concerned, you have the concurring and dissenting opinion of Justice Carpio in the case of Garciliano versus House of Representatives. What was his concurring and dissenting opinion? Insofar as all other matters and unpassed bills are concerned, deemed terminated. And he was referring to legislation. So that, with respect to non-legislation, the case of the one I mentioned, Pimentel versus House will come in. Impeachment is non-legislation. So therefore, if it has been started in June 2, 2025, it has to continue when the 20th Congress resumes or opens its session.
Thank you, Commissioner Sarmiento. Professor Rivera, Professor Te, just perhaps to add a little more context to this question, and to be, just to present a devil's advocate position, I think the position of some is that the Senate terminates on June 30, not just from a constitutional standpoint, but also from a democratic standpoint. By the time you have people selecting a new Senate with probably different priorities or policies, does that change any answer that you may have with regard to this question, or how would you respond to this question about impeachment crossing over from the 19th to the 20th Congress?
As Senate President Drilon mentioned, this is an open question. We don't want to prejudice a consideration of that question should it reach the Supreme Court. But at the moment, I think we have three theories on this point. The first is that it may continue into the 20th Congress for the reason that Commissioner Sarmiento had mentioned. The second is it may continue into the 20th, but it will be up to the 20th Congress, specifically the Senate, on whether they will take it up from where the 19th Senate had concluded its work, or if they will restart. And the third, of course, is that it simply does not continue into the 20th Congress for the reason which you stated. So if we look at members of the Senate and members of the House as duly elected representatives of the people, then certainly we must respect the views that may be brought into the question by those who will be duly elected in the 20th Congress, which would then, of course, it's not just a change in the composition. I had heard this as well on a number of news coverage, that there's the view that it's simply a change in composition which should not affect the continuous conduct of the trial, in the same way that, for example, the Supreme Court does not conclude a consideration of any case just because there has been a vacancy that has been filled with a new member. But I think it's very different from a legislative body, which is a representative body, and we should respect, for example, elections are coming, and we respect the vote that each one of us will be making on that day, and that may certainly include a vote on which representative I wish to elect and his view on this particular question. So I think those are the three sort of theories that we have here. But from a strictly legal perspective, we put together what we have based on Supreme Court decisions. It looks like it can continue into the 20th Congress, but the 20th Congress, particularly the Senate, will then have to consider whether it will continue or if it will start anew, which would mean constituting itself anew as an impeachment trial, reconsidering the rules for the impeachment trial, because none of the work of the previous Congress has any conclusive effect on the succeeding one.
Before we go to Professor Senate President.
Let us remember that the Senate is not the impeachment court. The Senate is completely a legislative body. The impeachment court, as we call them, is sui generis, a class of its own. So these are questions which are not easily resolved. And the issue that just like the appellate courts, it can continue to function. You could also make an argument against this proposition that this is not a court, this is not a body which is constituted by law, but it's constituted by a complaint of the House of Representatives, which, by the way, whose mandate would have also expired when this Congress expires. So does the impeachment complaint continue to be valid with the impeachment, with the impeachment complaint authors have lost their mandate because their terms have expired? Marami pong hindi masagot dito. And kaya maganda naman, nandito si Senator Robin Padilla. Siguro yung papakinggan niya rito, dadali niya sa Senado pagdating ng panahon. Salamat po.
Thank you, Senator Dillon. Professor Tab, before you answer, so I understand the hesitance to take up a position in a very difficult open question. I think for lawyers, the difficulty also comes from the fact that impeachment is not really a strictly legal proceeding, and therefore, the idea that law can rise above politics might not be as strong as, let's say, democratic accountability or legitimacy that really goes into the question of impeachment. So if I can, tease you a bit into taking a position, all difficult questions that the court decides are open questions before they get to them. Would you have any particular position on this?
I was about to make the analogy that Senate President Dillon made, that when the impeachment court has been constituted, it is not the Senate. In the same way that the Presidential Electoral Tribunal, once constituted, is not the Supreme Court, even though it is composed of all the members of the Supreme Court. It acts as the Presidential Electoral Tribunal with a different set of rules, with a specific mandate, and therefore, as far as regularity of the schedule, the Senate acting as an impeachment court may not actually be bound by that calendar of session, adjournment, recess, session, adjournment, recess, for purposes of legislative work. And so I would, well, since you teased me into taking a position, I would probably say that if it is based on that particular characterization of the Senate having been constituted, and I think this is the qualifier I would make, if it had been constituted as an impeachment court while the 19th Congress is in session, and once the 20th Congress comes in, the impeachment court will still stand, having been constituted already, because it is not the Senate acting as a legislative body. The question now of how many members and which members, that is now the difficult question, because practically half the Senate will have their terms ended. There will be new senators. There will be new senators coming in, and so that would have different implications. But I think that would be my position.
I think it's also worth noting, especially for the law students and lawyers here, and my own law students, that while the word impeachment court does not really appear in the text of the 87 Constitution, the practice of the Senate in the last two impeachment trials has really seemed to indicate it as sort of an independent creation or independent body. Legislative precedent is one of the ways we understand the Constitution, and so the idea, for example, that you would have a separate oath indicate that the Senate transcends to a higher political body than just the typical legislature. Senator Dillon.
Yes. Just a question occurs in my mind. An impeachment court is not an ordinary government agency. Suppose the politicians which constitute the impeachment court would make a political decision and say, we will not follow what the Supreme Court says. Can somebody tell me if you can declare them in contempt? In other words, what I'm saying is, there are really a lot. This is one question that bothers me. The impeachment court is not an ordinary government agency. It is a court created by virtue of an impeachment complaint filed by Congress. We say that the impeachment court is different from this. It's not the Senate. So can the impeachment court refuse to follow the ruling of the Supreme Court? And if it does, what will happen?
Justice Carter Morales.
I think whatever the impeachment court does is a political question. The Supreme Court would not take that up. That's my opinion.
I think that's supported also by the practice of the last impeachment, where the Supreme Court did order the non-disclosure or prohibited the disclosure of the bank accounts of Chief Justice Coron, and then the Senate voluntarily complied by voted on the decision to just to not open it. So it might be a signal on the part of the Senate to still assert control over the process. Commissioner Sarmiento.
May I just go back to the open question that was mentioned by Senator Frank, whether it is a continuing body or not. Well, originally, this idea of impeachment was drawn from the Greek experience, borrowed by the English system and perfected by the U.S., and then borrowed by us from the U.S. Now, meaning the U.S. experience has persuasive impact on rulings of the Supreme Court and our legal and judicial experience. Now, in one case, the case of the impeachment of Judge John Pickering, the impeachment articles were submitted on the last day. 7th Congress, the 8th Congress continued the trial of Judge John Pickering. In other words, learning from that experience, pwede pala na ituloy ng panibagong Kongreso yung naumpisahan na under the old Congress.
That's a very interesting perspective, Commissioner Sarmiento. Are there any last thoughts on this question from our panelists? Justice Carpio Morales.
Yes, why not? The next Congress can take over, continue, but as I said, it can also be understood to mean that it is as if the matter has been presented for the first time.
Yeah, that's also possible. Prof. Gwen?
I think the emphasis here is so many of these questions are really addressed to the Senate, because the language of the Constitution is it has the sole power to try the impeachment case. So I think observing that constitutional language means the Senate has to consider very carefully how it will proceed, because it's also not bound by any step that it had taken in the previous impeachment trials. That's the first point. The second point is, as you had pointed out, the 1987 Constitution does not carry the words impeachment court. In fact, the specific provision addresses itself to senators. It says that the Senate has the sole power to try impeachment cases, and when the Senate sits for that purpose, it is the senators who take the oath or affirmation. And that's basically the constitutional requirement as far as the Senate is concerned. That is why I think there's a wide discretion on the part of the Senate with respect to the actual trial of an impeachment case.
And I think taking with what Justice Carpio Morales said, that the Senate acting on this as a political question, then it also raises how, unlike the typical case where we have the Supreme Court informing us of how to conclusively read the Constitution, the Senate might actually weigh in more heavily on this point, whether it will decide to continue the impeachment trial.
Well, not to monopolize the conversation, but there are just two interesting points.
Yes.
Based on what you've shared. The first one is, in the U.S., based on their practice, there's that case of Nixon versus U.S.
Yes.
That's Judge Nixon. And for his impeachment, I think based on even an earlier impeachment case, what the United States Senate had done was to actually constitute a commission for purposes of taking in evidence, and that commission would render a report to the Senate as a whole, so that the senators can continue with their legislative work. Of course, in that particular case, the U.S. Supreme Court refused to rule on whether that was not unconstitutional, because they consider it as a non-justiciable question. Of course, in our own jurisdiction, we've resisted adopting that view that had been taken by the U.S. Supreme Court, and our decisions say that there are questions related to impeachment that may be considered as justiciable, particularly if there are standards that are provided in the Constitution against which the validity of a particular conduct can be assessed by the Supreme Court. So, so many questions arising from this particular case.
Thank you, Prof. Gwen. If we could...
That's why I suggested a special session. The impeachment court is constituted, the trial takes place, and finish it before the term of this Congress expires. So all these questions will not come to fore, because it will become academic with the decision, which I'm sure can be rendered before Congress expires. There are a lot of questions that will be raised here, and I don't know when it will be resolved.
That's right, Senator Dillon. So, the difficulty with these open questions could have been solved if the President called a special session.
That calls for the conduct of trial, full trial up to its conclusion under the Ninth Senate, on the assumption that there would be no difficulty presenting evidence on the part of the prosecution and on the part of the defense.
That's right, because the last impeachment trial also took around 5 months before it finished. And
It can't be finished. I have gone through it. It can't be finished. Because the senators would not want to be bogged down there. They would want to decide it expediently. There is nothing that prevents the impeachment court or the Senate from meeting from 8 o'clock in the morning to 8 o'clock in the evening. And, we have gone through it. We would hold sessions, impeachment trials for hours, 10 hours sometimes. So, but because of these many difficult questions that will arise if you allow the impeachment trial to spill into the next Congress, I thought that the best solution is just call a special session, then hold the impeachment trial forthwith.
thank you, Senator Dillon. Justice Carpio Morales, as a
Just
last
want to
point.
put on record that Senator Robin Padilla is nodding his head. So you have a supporter.
Thank you, Justice Carpio Morales. If I can...
Just to add to Senate President, actually we were having a conversation earlier, and even from a litigation perspective, we were thinking that would be there are already pending petitions today, but that would be the neatest if the entire proceeding could be completed within the 19th Congress.
Thank you, everyone. If we can move on to the third question, which is itself quite controversial. There have been views that the Vice President's resignation will result in the cancellation or pre-termination of the impeachment trial. And I think those views are informed by past impeachment practice. The resignation of President Estrada resulted in the termination of that impeachment court. The resignation of Ombudsman Merceditas Gutierrez, Andy Bautista resulted in trial not proceeding. But we also have quite recent practice from the United States where, because of the disqualification consequence or question, their U.S. Senate decided explicitly to push through with trial even if President Trump had already resigned by that time. So your views on this question?
This one is clearer. There are two consequences of there are two issues which the impeachment court will resolve. Number one, the issue of dismissal from office, and second, perpetual disqualification from holding public office. The resignation will make the first question academic, but the second issue is valid, perpetual disqualification from holding office, which will justify or which will provide basis for the continued trial in order that a decision can be rendered on the second issue. This issue, however, would have to be addressed to the impeachment court. In other words, it becomes a political issue and question whether or not, political in the sense of politics, whether or not the impeachment court will continue and continue to hear the case in order to rule on the second issue, which is perpetual disqualification. In the past, the impeachment court simply said, enough, ayaw na namin, uwi na kami. So wala na. So theoretically, the impeachment court can continue and decide on the second issue. But that's in theory.
Senator President Dillon, before I go to the other panelists, I think your experience here will be very valuable since you're the only one in this room who has decided an impeachment trial, especially the one in 2001, where the Senate decided to terminate the trial once President Estrada stepped down from office. Would you be able to share to us the reasons why the Senate decided to pre-terminate the trial instead of continuing to that question of disqualification?
Well, this is the impeachment trial for President Estrada.
Yes, the 2001 impeachment.
Well, the EDSA DOS made it academic. When, theoretically, we could have continued with the impeachment court, in theory. But given the political situation at that time, I don't think it made sense for us to continue the impeachment court. We could have argued that the impeachment court should continue to exist to tackle the second issue, but we, under the circumstances then, we said no more, enough.
Probably highlighting also the very political character of the exercise. Thank you, Senate President Drilon. Our other panelists, would they like to weigh in on this question? Commissioner Sarmiento and then Justice Carpio Morales.
I don't think it will affect the impeachment trial, the resignation, or a preemptive move on the part of the impeachable officer. Remember that under the Constitution, the Senate has the sole power to try and decide. In other words, it's up to the Senate. It's a political question. And one Supreme Court decision said, because of that sole power, it's hands off for us to interfere. It's purely a political question on the part of the Senate.
Thank you.
The Supreme Court cannot compel the impeachment court to continue being in session and try the second issue, which is perpetual disqualification.
Thank you, Commissioner Sarmiento and Senate President Drilon. Justice Carpio Morales, your views, please.
The question presumes that the resignation is made when trial has already started. Because if not, like the case of Andy Bautista and Mercedes Gutierrez, they were scot-free because I share the consensus that resignation when trial has started would not necessarily call for the dismissal of the articles of impeachment, because as intimated by Senator Drilon, impeachment is not for the protection of the respondent. It's for the prevention of abuses, continuous abuses, and for the protection of the public from being the subject of, call it corruption, bribery, high crimes, although high crimes defies complete definition. Thank you.
Thank you. Prof. Gwen and Prof. Ted, your views, please.
I agree. That particular question is again addressed to the Senate. So the Senate may decide to continue with the trial even though the impeachable officer or the impeached officer, so long as trial has already commenced, even if that official has already resigned. I think even for other public officials and employees, if there's an administrative case that's already pending, it will not be dropped just as a result of a resignation.
Thank you, Prof. Ted.
Concur.
I just clarify the administrative aspect of the case. An employee or official may resign if he or she wishes to, but if the employee or official resigns to jump the guns, in other words, aware of the impending filing of a administrative case, even if an administrative case has not been filed, he can still be within the jurisdiction, administrative jurisdiction of whoever is in charge of him or her.
It's a very important.
Just in theory, even if the impeachment court has not been constituted, even if the respondent has resigned, in my view, the impeachment court can still be convened for the purpose of the second issue, perpetual disqualification, because that's jurisdictional, that's within the power of the impeachment court, and therefore it is not academic by the resignation of the respondent before or during or after the trial.
Justice Carpio Morales.
Senator Drilon, how come you did not carry out that view when you were still an incumbent during?
Because the reality is, after undergoing that trial, it is so tiring that you don't want anymore, to do it. Having sessions morning and afternoon is not easy, especially,
Then let's have senators who are young so that they'll not be enervated.
That's why I'm not running anymore.
As a 10-year-old political nerd, then Senate President Ron, that was my political awakening, that impeachment trial in 2001. So I think for the information of our audience, the reason why this was brought up was it keeps getting raised in media interviews concerning what happens, can she avoid disqualification? Can the Vice President avoid disqualification if she just resigns? Because the impeachment trial would not proceed anymore. And I think there's some consensus here that there is a second consequence to impeachment, which is not just removal, but also disqualification from office. And a unique feature of that is that unlike any other penalty in law, that disqualification from office is actually not pardonable. So it's a very high penalty that the Senate can impose as representatives. Professor Tay.
I just wanted to say that I'm glad that we're using the word consequence rather than penalty, because in criminal law, a perpetual disqualification is an accessory penalty, but in impeachment, it's not considered as an accessory penalty. It's a consequence of a conviction. So as Senate President Drilon has pointed out, there are two consequences: removal and disqualification. So while the resignation may actually preempt the removal should the conviction happen, the perpetual disqualification remains a live and pending issue. And so should that happen, it should not be treated simply as an accessory to the main penalty or consequence. That's why I don't want to use the word penalty, because it shouldn't be used. Unfortunately, we use the word conviction, which tends to mislead, because if we're thinking criminal law terms, conviction carries a penalty. But it does carry the two consequences, which are separate and distinct. The second point I'd like to make is because carrying out the trial despite resignation of an impeached public official just to determine the disqualification is consistent with the purpose of impeachment, to ensure accountability, because otherwise mootness will just simply sweep that down the road, right? It will just remove every attempt to make a public official accountable. The public official evades the removal and also evades the disqualification, while impeachment really is the constitutional last resort for as far as these officials are concerned. The offenses are so grave as to merit impeachment as a way of removing them, and therefore we cannot just simply say by rendering it moot by resignation, even the aspect of whether this person could ever be allowed to hold public office would simply be swept away. So I would support that consensus, but would want to point it out that because of the consequence of just using mootness, we really should disabuse, right, the public of that particular consequence, that it is simply an accessory to removal. It is not. These are two separate and distinct consequences.
The principal consequence of that. If we can move on to the fourth question, just because for the lawyers here, is there a standard of evidence in impeachment trials, or should there be? And the reason why I ask is that in 2012, during the Corona impeachment, one of the key issues raised by then Senator Santiago, Defensor Santiago, was what would be the standard of evidence. Now, for non-lawyers, the standard of evidence is basically how much proof should there be before a particular judgment is given by a court, and in this case, the Senate. Is that question at all relevant? Does it risk the over-legalization of impeachment? And
what could be the consequences of that. Commissioner Sarmiento, and then probably Professor Te and Senate President Drilon.
If I recall right, it was an issue during the impeachment of President Estrada. And again, an issue during the impeachment of Chief Justice Corona. What is the quantum of evidence? Should it be proved beyond reasonable doubt or sufficient evidence? Again, to the best of my recollection, it was not proved beyond reasonable doubt. This is very difficult. I think it was sufficient evidence would be enough as guide for the senators in, well, convicting or acquitting the respondent.
Well, I don't think proof beyond reasonable doubt is a standard. That's only for crimes, you know. I think during the time of, during the impeachment of Corona, what was actually followed was the overwhelming preponderance of evidence. Preponderance of evidence, in one case it has been said that it's more than 50% chance of getting the desired result. So again, it's because it's the Senate which is given the sole power to come up with its rules, then we respect whatever burden of proof the Senate will exact from the parties, but certainly not proof beyond reasonable doubt. Thank you.
Senate President Drilon.
Remember that the senator judges are not lawyers. Many, some are lawyers, some are not. But having said that, there is simply no standard of evidence that is required. Each senator judge would make a judgment on the basis of his or her appreciation. There is no standard that is imposed because it's simply not possible to impose that kind of standard. Because in the first place, we say that the impeachment court is a class of its own. So, you know, from that alone, you can have many consequences. And it's difficult, really difficult to impose any standard because the members of the court are simply politicians in the first place. They are not lawyers in every instance. So it is addressed to their conscience how they would perceive the evidence presented.
Thank you, Senate President Drilon. For Prof. Gwen and Prof. Ted, I wonder if you can tie this question to questioning the question, the larger issue about the way that law and politics interacts in impeachment. Because it does look like and feel like a legal proceeding. We call the senators senator judges, there's a prosecution team, there's a defense team. But in the final analysis, it seems like a lot of the rules that we would apply to courts actually do not apply to the Senate. And what would that mean for questions like evidence or burden of proof?
Thanks for that question. The first thing that I'd like to say is that the very first rule under the rules of court regarding evidence is that it applies only for judicial proceedings. So when we talk about evidence, unless the Senate expressly adopts the rules on evidence, which I do not think it should, because as Senate President Drilon pointed out, they are not all lawyers. So, you know, the complicated, technical, nuanced appreciation of evidence may not work for all of the senators who are not lawyers. They are not trained in those rules, and therefore it shouldn't bind them technically. Secondly, because of the political nature of impeachment, I think the standard, and I wouldn't say standard of evidence, the standard, I think, from which any evidence is appreciated by the senators should be, what would I, as a senator need to be convinced of to remove this elected official from office and bar this official from ever being able to assume office. Whatever that standard is, that should be how the senator views the evidence. Because again, you can't use preponderance, you can't use a reasonable doubt, you can't use substantial evidence, which is so low a bar in terms of administrative proceedings. And because it's sui generis, as Peter Lon points out, I think the point of view of the senator should be, hearing everything that I've heard, does it convince me, does it answer this question for me, that this impeached official should then be removed from office and should be barred from ever assuming office? And that's a very heavy burden. That's a very difficult question because, again, you're contending with, an elected official who has been put into office by the will of the people, and your vote as a senator is essentially to override that decision of the people, right? In putting that person in office for whatever offenses this person has done, and that has been proven. So I do not think the standard should be the legal standard that we lawyers are used to. I'm trying to recall who it was who said, I think it was Senator Lapid in the Corona impeachment. His explanation of vote was so simple, from the point of view of an ordinary person. You may agree or disagree with his explanation of vote, but that was how he perceived the issue. And so I think from the point of view of the senators, when they're viewing the evidence, they should be viewing it with the end in mind of answering that question. What would convince me that this person should be removed from office, overriding the vote that this person got, and perpetually barring this person from ever holding any office? Those are two very difficult questions to answer. And maybe just as a third point, Paolo, in relation to the use of evidence, over judicializing the proceedings, right, may also get in the way of impeachment as a mode of truth telling, of finding out the truth regarding certain transactions, certain grounds. Because again, the litigators know that one way to get a judgment in your favor is to make sure that the evidence never gets in. So hearsay objections, all of those things, right? But if for example the Senate takes on an overly judicial approach towards receiving evidence, right? And therefore there's hearsay objections all around. Essentially, you don't get to hear what's behind the accusations, right? And so maybe a shift in the mode, right, of adversarial, which we're used to in court, right? People versus X and Y, A versus B, from adversarial to inquisitorial, where the Senate, acting as inquisitors, right, basically try to find out, is this true? And, even if it would be hearsay, right, as long as it is supported by enough corroboration, perhaps the Senate can go beyond that. I say that because of the qualification that the rules of evidence are really for judicial proceedings. They're not really for other types of proceedings.
But the rules of evidence is supplementary to the rules of the impeachment court.
Yes.
And if let's say an objection is raised on that the evidence is hearsay, that can be ruled by non-lawyers. That can be decided by non-lawyers because that is put to a vote in the impeachment court. So, in that sense, the rules of evidence has a supplementary application.
I agree, sir. But what I'm simply, I think, pointing out is that we should not overly judicialize the proceedings. Because I think the other function of impeachment, the trial itself, which sometimes gets overlooked because of the adversarial nature, the perspective that it is adversarial, is the fact-finding, the truth-telling aspect of the impeachment court.
Scholars would actually call it not so much legal accountability, but political accountability.
Yes, political accountability.
And hence the morally coded words of the Constitution on impeachment. Prof. Gwen, before we probably go to the last question.
Maybe just 2 quick points. To the question, I agree with Senate President Drilon. The Constitution does not itself require any standard of proof, nor any quantum of proof in the impeachment trial. And from a practical perspective, I think it will be difficult to impose such a standard because the determination of whether the impeached official's conduct rises to the level of an impeachable offense is addressed to each senator judge. Because at the end of the day, the conviction or the acquittal in an impeachment trial is just a matter of votes. So we look at, so that question is really addressed to each senator judge, and as Senate President Dillon mentioned, not all of them are lawyers. The second point is, while we're discussing burden of proof, I think there are 2 important sort of strands to that question that the Senate should pay attention to. One is their crafting of their rules for the impeachment trial. In the past, I understand that they have adopted the rules of evidence in a suppletory manner. We don't know whether that has affected in any way the capability of a non-lawyer senator judge in receiving information. That's one. The second is if it has affected the capability of parties, for example, the House managers or the House prosecution panel and the defense in terms of presenting information to the Senate for purposes of each judge making that decision. Lastly, also the role of the presiding judge. So in the last 2 impeachment trials, both were lawyers. So Chief Justice Davide and Senate President Juan Ponce Enrile. And you will see in how they've managed, I don't want to say judicialization, but you'll see on one hand how previous experience in running adverse proceedings has helped expedite the proceedings, how quickly they decide on motions. But at the same time, we don't know whether that has in any way disadvantaged those who are senator judges without similar experience. So apart from quantum of proof, and again, I think there really isn't one that we can impose. We should look at the role of the presiding judge and also the manner by which the rules for the trial will be crafted by the Senate.
I think ultimately as well, if we go by the language of the Corona and Estrada impeachments, there was a lot of language pertaining to conscience, whether the conscience of the senator judges would be satisfied by the vote that they would have ended up taking. We have just a few minutes for the very last question for this panel, which is very timely in light of events. In just the last week when we planned this impeachment forum, there was no case filed yet to the Supreme Court, and now we have 2. Right? So if a case is brought to raise these questions, may the Supreme Court step in. And I think, for our audience who may not be lawyers or law students, there's a question there's a difference rather between whether the court can step in and whether the court should step in. May kapangyarihan ba siya o dapat ba siya manghimasok doon sa issue na iyon? So, your thoughts on this, Commissioner Sarmiento?
Address the last question. As of today, the Senate has not been constituted as an impeachment court. So not yet the sole power to try and decide this case. So if addressed, that question, may the Supreme Court step in. Now, there is this provision, forthwith proceed. That's why a petition has been filed by a lawyer for the Senate to observe, to follow this command, forthwith proceed. So up to this point, it is not yet an impeachment court. It's not a political question. I think the constitutional duty has to be addressed by the Supreme Court. Now, on the issue of the second petition that was filed with the Supreme Court yesterday, questioning the whole process that was followed in the House of Representatives. Again, there is a provision in the Constitution that's to be followed. I think the Supreme Court can step in and come in and resolve this petition.
Thank you, Commissioner Sarmiento. Senate President Drilon.
The basic rule is found in the Constitution. The impeachment court shall decide all impeachment cases. Questions of jurisdiction, therefore, should be decided by, according to the Constitution, by the impeachment court. To me, the better attitude that the Supreme Court can follow is not to interfere. Let this be treated as a political question and therefore leave it to the judgment of the Senate asking or acting as an impeachment court to decide on this, including questions of jurisdiction. So it's best that the Supreme Court does not interfere.
Justice Carpio Morales, I know that there might be a discomfort in light of the Francisco ruling.
Under the expanded jurisdiction of the Supreme Court can take jurisdiction in actual cases, actual controversy that involves the rights, demandable rights of people. And when there is abuse of, or grave abuse of discretion. So, for as long as the question is not political, but there is abuse of discretion, grave abuse of discretion on the part of the respondent, and or there is an actual controversy that involves demandable rights, the Supreme Court can step in. Thank you.
In other words, the decision of the impeachment court can be appealed to the Supreme Court?
Why? Are you sure there was abuse of discretion?
Well, just my point, Chit, is that under the Constitution, the Senate shall have the sole power to try and decide all cases of impeachment.
Precisely.
This is precisely a clear rule that the Supreme Court should leave the Senate alone.
Precisely, I subsume my answer in that there is, under the expanded jurisdiction of the Supreme Court, as afforded by the 1987 Constitution, the court comes in if there is an actual case and it involves demandable rights and or there's grave abuse of discretion. If the impeachment court gravely abused its discretion, why should it not step in?
Because the remedy is not to re-elect the senators that rendered such an unjust judgment.
You tell that to those who are electing and re-electing.
If I can just provide context to the discussion, before the 87 Constitution, I think there was, impeachment was clearly beyond the interference of or the intervention of the judiciary, if that might be a better word. But the position since 87, at least by the court, is that there are some questions that were formerly, the court would not really decide, are now fair game for the court's decision. I think Senate President Drilon is on the side of the traditional idea that, the impeachment is a political process, the court should step back. Justice Carpio Morales is more on the expanded jurisdiction of the court. If Prof. Gwen and Prof. Ted can weigh in, just as...
Go ahead. On the matter of electing and re-electing.
Yes. I want that point should be given emphasis. But to your question, I agree with Justice Carpio Morales. As the Supreme Court has done before, there are questions related to impeachment which the court has considered to be justiciable so long as the standards for adjudication are present in the Constitution. But having said that, I understand your question to mean any of the questions we've discussed today could be subject to sort of judicial review. on that point, I agree with Senate President Franklin Drilon. I think this is an opportunity for the Senate because the articles of impeachment have already been transmitted, or the impeachment complaint as the articles of impeachment has already been transmitted to the Senate. I think we should give the Senate the opportunity to take on the role that it has been constitutionally granted, so that its action will inform how these provisions are enlivened, rather than by default letting courts decide questions that have been addressed by the Constitution to the Senate.
Thank you, Prof. Ted.
Yeah, there's a balance that is struck by the Constitution among the three branches, and that balance is now being implicated whenever impeachment comes in, because there are two branches of government currently now being involved with the impeachment of the Vice President, and then the action of the House, and then the possible action of the Senate. You're now bringing in a the third branch to mediate in a way between these two branches of government. And so, knowing the court to also be a practical court, meaning will its action actually do anything in order to help the situation or not exacerbate the situation. While I agree that yes, the court has jurisdiction to entertain petitions that fall within Article 8, Section 1, Paragraph 2 parameters, the question of should it is a more difficult one, simply because of that balance. And on a practical matter, for example, in one of the petitions, where the petition asks that the Senate forthwith proceed, meaning should try, right? When the court, I imagine if the court acts on that, and if the court acts favorably on that, that would mean the court would be setting the timetable basically for Congress to do certain things, where objectively those conditions may not exist. And so I think that would be within the mind of the court. Can we actually grant this relief, considering the objective conditions do not exist? The Senate has not been constituted yet as a court. If we do grant this, how will the Senate proceed? Because the court cannot order the Senate to constitute itself as an impeachment court. They cannot order that in whatever petition. So that's why I preface my answer with that there's that balance, and the court now being called to mediate, to thread that balance. The court will have to look at the practical side of its decisions. Yes, the jurisdiction is there, but I think the question would be, should it exercise its jurisdiction at this point, and maybe not when at a future time when maybe the issues have been a bit more crystallized, as opposed to at this current time. I hope I don't get cited for sub judice for that, but that's my opinion.
I think what lawyers would call ripeness, when all of the facts are already there for a court to make an informed decision. That has been an incredible hour and a half, and I hope, I wish we could continue the conversation, but may I ask our audience to give our speakers another round of applause. I hope our speakers can stay up to the open forum towards the last few minutes of today's session, but in the meantime, may I call on Professor John Molo to introduce the speakers for the second panel.
Our second panel for today has two speakers. First one is Honorable Isabel Maria J. Zamora, who is part of the House Panel of Prosecutors. She is the incumbent representative of San Juan City's Lone District. Representative Zamora is part of the panel of 11 representatives who will serve as prosecutors in the impeachment proceedings of Vice President Sara Duterte. Prior to entering politics, she was a partner at Zamora Poblador Law Offices, practicing civil and family law, corporate law, and criminal law. She received her undergraduate and law degrees from the University of the Philippines and was admitted to the Philippine Bar in 2009. Our second panelist is Attorney Sheila C. Sison, a partner from Fortune, Narvasa, and Salazar. She is counsel for Vice President Sara Duterte. And Attorney Sison is a specialist in criminal litigation and has served as lead counsel of numerous Sandigan Bayan cases. She has extensive experience in criminal and civil litigation, family law, and labor law. She earned her Bachelor of Laws from San Sebastian College of Law and graduated as class valedictorian. She was the first recipient of the Academic Excellence Medal of Honor by the Recoletos Educational Apostolate of the Philippines. Ladies and gentlemen, our panelists for today.
May we call on Congresswoman Zamora and Attorney Sison to the stage for our second panel on the Duterte impeachment and lessons from the past. Thank you. Thank you so much. Like the first panel, we did provide Congresswoman Zamora and Attorney Sison with a few questions over the weekend, and we're very grateful that you took the time to be with us today. The panel is going to be much shorter than the first one, but before we get to the questions that we prepared for you, would you have any reaction to the first panel or any thoughts that you may have following the first panel that was here? Oh, I'm so sorry. So before we get to the or to the question and answer, I understand that Congressman Zamora prepared a brief remarks. Would you like to deliver them?
Dean Darlene Barbarabe, Senator Robin Padilla, former Senate President Franklin Drilon, retired Associate Justice Conchita Carpio Morales, Commissioner Rene Sarmiento, my professors in the UP College of Law, non-teaching staff, guests, students, good afternoon. I am Isabel Zamora from Batch 2008, Block C, and it is my honor to once again be in the hallowed halls of the University of the Philippines College of Law, albeit in a different and fancier location. Never in my life did I think that I would speak in front of my professors or be chosen as a prosecutor in an impeachment case, as I always regarded myself as a simple girl. The role of being a prosecutor was offered to me on our last week of sessions, and I accepted the offer for several reasons. First, I was asked if I wanted to do something for the country. Second, as vice chairperson and an active member of the Committee on Justice in Congress, I believe that it is my duty to see the complaint through. Third, I was told that they needed someone who was matalino, mabait, at maganda. So I said, hindi naman. I initially had doubts after I was nominated, as I thought I was not a great trial lawyer. But sabi nga, para ito sa bayan. I was tasked by my friends, Congress colleagues from UP Law and UP, to wear something maroon on the first day and to raise the flag of UP high. I am both excited and anxious about my new task. I brought out my highlighters and post-its the following day and started reading. It brings back tons of memories from law school. I take this opportunity to mention a few aspects about the case. The complaint was culmination of a meticulous, transparent, and televised fact-finding effort of the House of Representatives. Certain matters, in fact, arose during the budget deliberations in 2023. Copies of the complaint were circulated to the members, and in fact, on the first circulation, I was already able to read the articles. Some members voiced their opinions on the matter. 215 members signed the complaint. The House prosecution will show that Vice President Duterte, since her assumption to office, has repeatedly, egregiously, and grossly violated her solemn oath and pursued actions that amount to culpable violations of the Constitution, flagrant betrayals of public trust, graft and corruption, and other high crimes. In particular, Vice President Duterte committed the following. She contracted an assassin and plotted to murder the President, the First Lady, and the Speaker of the House. She misused and malversed confidential funds appropriated for the office of the Vice President and the Department of Education. She disbursed or gave away monies amounting to graft and corruption, among others. The House prosecution has been meeting and preparing for trial to commence, as we believe that there is no other interpretation to the provision in the Constitution that trial shall forthwith proceed. I have so far been able to gather a lot of know-how, insights, and intelligence from the other panelists today and my professors today. I am extremely grateful for this opportunity, and I thank Dean Berberabe and all of you for bringing me back to the university that I love dearly. Thank you.
Thank you, Congresswoman Zamora. I understand that Attorney Season also has a few remarks.
Dean Darlene Marie Berberabe, the Senator Robin Padilla, retired Supreme Court Associate Justice Honorable Antonio T. Carpio, former Senate President Franklin M. Drilon, retired Associate Justice Honorable Conchita Carpio Morales, Honorable Rene V. Sarmiento, Attorney Ramon Esguerra, Associate Professor Gwen Grecia de Vera, Assistant Professor Theodore Te, Congresswoman Isabel Maria J. Zamora, Attorney Fina Bernadette A. de la Cuesta Tantuico, and my senior partner in Fortune Nervasa and Salazar, Attorney Gregorio Y. Nervasa II. Ladies and gentlemen, good afternoon. I would like to thank the UP College of Law, Justice George A. Malcolm Memorial Foundation, Inc., in partnership with the Philippine Law Journal, for the invitation to join this forum today that aims to encourage meaningful conversations on the emerging issues in impeachment, especially since we come to this forum as counsel for the Vice President, whom we know is now the subject of impeachment efforts. We appreciate the opportunity given to partake in today's discussion. and listen to perspectives from which we could all draw some insights that hopefully would enrich the dialogue and our understanding, as well as of the public, about the impeachment process. The other night, I was reading a keynote speech that was delivered by the late good Senator Miriam Defensor Santiago in 2012, or 13 years ago. This was delivered before an annual convention of a Society of Doctors and Physicians. Now, in that speech, she cited the fundamental book on the topic of impeachment, authored by Professor Charles Black, Jr. of Yale University, and summarized as well the thoughts that the latter had on the matter. According to the late senator, impeachment is a dreadful process. It inflicts a deep wound on the country. Now, Professor Black, in his disposition in that book, described impeachment in this way, and I quote, "Removal by conviction on impeachment is a stunning penalty, the ruin of a life. Even more important, it unseats a person whom the people have deliberately chosen for that office." I understand, of course, that many who had come to this forum may probably already had formed their own opinions. This is but natural in a democratic country that values and encourages free speech. But I agree, it is a stunning penalty. It is a dreadful process. It ruins a life. In fact, I can even go one step further and state the reality that long before the impeachment process has begun, a life is already ruined by accusations made public, and with the amount of heavy criticisms made for public consumption without the benefit yet of a trial. And perhaps that is the significance of having this forum today, in that we are reminded that despite our personal convictions and or opinions on issues surrounding the current impeachment efforts against the Vice President, impeachment remains a serious constitutional mechanism that must be done only in the manner permitted by no less than our Constitution and the standards it had set therefore, in accordance with principles of fair play and the rule of law. I am hopeful that this forum would contribute to elevating the discussion among our people. Again, good afternoon at maraming salamat po.
Thank you very much, Attorney Season. Congresswoman Zamora and Attorney Season, to go to the questions that we raised over the weekend and which we gave you ahead of time, we would like to ask, how do past impeachments or past impeachment trials inform your preparation for this upcoming trial, if you could answer it? Congresswoman Zamora.
Professor Tomasa, so as I earlier mentioned, the prosecution has already been reviewing and studying and preparing for the trial. So in fact, we studied the past impeachment cases. We have a list, tables of all impeachment cases filed before the Committee on Justice or those that went straight to plenary. And I know two particular impeachment cases. First, in President Estrada's impeachment, we know that there was an issue of the second envelope. I was not yet a law student at that time, but from my understanding, there was a need. They wanted to open it, and that was the reason why the senators walked out, because of that second envelope. So what we thought was that there's a need to sift through our evidence. We should check all the pieces of evidence that we have and see whether these are really important. Second, learning from the era of impeachment was that public support is very important, as this is a political exercise. It is political legal for some, but the influence of the public is very important, and we should muster the public support in this case. Second, that I noted was in the Corona impeachment back in 2012. If I'm not mistaken, several articles were withdrawn. I believe it was 5 articles. And that tells us on the prosecution side that we should in fact be ready with our articles. We should be able to defend these articles and have evidence for each. We should prepare so that we won't be berated by Senate, especially the lawyer senator judges. As in fact, some were berated. Some of the members of the prosecution were in fact berated by Senator Miriam, if I'm not mistaken. I believe it was during that impeachment also that they were berated on rules of evidence, and this tells us that we need to have a cohesive prosecution. We have to have a firm stand and complete evidence for all of the articles.
Thank you, Congresswoman Zamora. Attorney Sison, would you like to weigh in on this question?
Yes. Earlier, I was actually asking my senior partner, Attorney Audrey Narvasa, about this question. And I told him it should be you who should answer this question because you're older than me. And he was part of the era Estrada impeachment defense team. And I think I was still just being born at the time. So really, if there's anyone who can answer this question in this room, that would be Attorney Audrey Narvasa. But all right, kidding aside, 2 things come to mind when it comes to past impeachment trials and how it would help us in the upcoming trial. But let me just point out before I answer this question, because the premise of this question is there will be a trial. And I think I have to be candid enough to disclose that yesterday the defense filed a petition challenging the validity of the 4th impeachment complaint that was referred by the House to the Senate. But let's assume that trial would indeed proceed. How do these past impeachment trials inform the defense team? In response to the question, Attorney Oji shared that during their time, which was 25 years ago, anything goes. There were a lot of things that happened outside the impeachment court, and I suppose that is because impeachment process really is a unique intersection of law and politics. And this is something that we also anticipate could happen and would happen this time. Because even now, prior to the Senate constituting itself into an impeachment court, we could already hear a lot of people wanting to put in their 2 cents on the matters and on all incidents, on all issues that come out of this whole impeachment process. In fact, even prior to the filing of the 4th impeachment complaint, we could already see and hear a lot of people chiming in on the things that were discussed at the hearings that were conducted by the House. And of course, this contributed to our people developing some opinions. Probably most of them are strong opinions. And so this is something that the defense would also have to prepare. Well, this is, not without, it goes without saying that we are prepared just by being the lawyers of the Vice President, that we would be under heavy scrutiny by the public. And so this is also something that we really need to prepare. But apart from the preliminaries, just like what Congresswoman Zamora said, the defense team is ready. Whether or not the petition or whatever resolution or action that the Supreme Court would have on the petition that we filed yesterday, the defense team is ready. Now, on the details of the preparation that we had done, I think that it would be prudent on my part not to disclose yet the level of preparation or the things that we are doing at the moment in order to be able to come to the trial well prepared.
I understand the limit, and nonetheless, we're very grateful that you actually agreed to our invitation to join the conversation this afternoon.
Yes, as I advised you when you extended the invitation to us, I really cannot disclose or discuss any matters pertaining to evidence, strategies, or defense. That's why there was a question that I actually requested you to take off the list because it's really something that I cannot talk about.
Which we also removed the equivalent question for the prosecution.
Yes, I understand.
So, but I hope the next question isn't, you'd be willing and free to answer regarding questions about the Senate rules. And unfortunately, despite impeachment being political, and that's something we learned from the first panel, inevitably, the proceeding itself is likely to be couched in law. And, it will involve statutes, it will involve the Constitution itself, and the rules of the Senate. So, having looked into the current Senate rules for impeachment, is there anything coming from the conversation the earlier panel or throughout your preparations which you think or you would want the Senate to consider or reconsider as part of the impeachment process?
Exactly. There's actually one. Proceeding from the discussion earlier and from what has been discussed even in media, there is Section 11, if I'm not mistaken, that an adjournment of the Senate sitting as a trial court shall not operate as an adjournment of the Senate as a legislative body. So in my humble opinion, I think that the reverse should actually be stated as well, so as to remove all of these issues on whether we can proceed with trial.
Thank you, Congresswoman Zamora. Attorney Sison, would you have anything to suggest?
I actually prepared 2 items in respect of this question, but based from the discussion that we had with our legal experts in the first panel, it would seem that the general track or agreement, at least, is that there could be no standard of proof or the degree of proof by which impeachment cases can be decided by the Senate. And whether it is clear and convincing, substantial evidence, mere preponderance of evidence, or beyond reasonable doubt, proof beyond reasonable doubt, I think that is something that we could agree is not included in the rules just as yet. And I would understand why. It's because if you read the rules on impeachment, really the senators, judges would mostly be deciding on the entire matter of the impeachment, as well as the incidents or the mini incidents that will crop up in that trial, based only on their conscience and based on the oath that they will be administered, that they would promise that they will do impartial justice. So one of the items that I wanted put, if I have my way, would be, a certain standard by which the impeachment process would be decided. And the reason for this is not because I want a higher quantum of proof. Of course, I want a higher quantum of proof. I'm a defense counsel. If it's going to be, if I have my way now, Senator Padilla, would you, consider putting in a standard of proof that, it's proof beyond reasonable doubt, or probably much, if there's any higher creature than that degree of proof. But the reason why I want some standard put in the rules is because, isn't it also in the public interest that we have some uniform standard by which the senators, judges would be able to consider every incident and motions that would come up in the trial? Because then it would lend not a semblance of legitimacy, but it would at least deflect questions on whether the proceedings that were conducted by the Senate and the rulings that the senator judges made were legitimate or at least fair. The second, of course, is just, on the more practical considerations. Perhaps it's also for the benefit of the prosecution team or Congressman Zamora. Perhaps both parties, if trial would indeed happen, perhaps a set timeline of everything, the submissions of motions, the examinations of witnesses, just so both parties or clear expectations are set for both parties. I guess this is also because largely this would be a public affair, and by public affair I mean everyone will want to, watch the proceedings and see how it's going.
Attorney Sison, if I can ask a follow-up question on that, does it mean that the defense and Congressman Zamora, the prosecution would, for example, be open to, let's say, a pre-trial proceeding before the Senate, or where for the non-lawyers, where basically the parties present the witnesses that they will present, the fixed list of the evidence that will be presented? And I think that the Corona impeachment has something like that at the very least, or even almost pre-trial discovery, as what the Nixon versus United States Senate did. If only you're comfortable with answering that question.
This is for me.
Yes.
I think the general consensus is to make the trial conform with the standards rules or fair rules, but also in an for the trial to proceed in an efficient manner. That's where I'm coming from. If the rules would be able, or the Senate would, for example, be able to come up with something definite, something that both the prosecution and the defense would have to pay in respect of the proceedings that would be conducted in the Senate, I think that would be in keeping with giving the entire process not expediency, but some order that no one would be able to question the legitimacy of the entire process, or even, the separate votings that the senators, judges would eventually make on some issues.
Congresswoman Zamora, your thoughts?
Actually, I agree with her statement that there should be some order to the proceedings. Going back to the standard, to the requisite standard that we need to convict. I agree with my professor Te that it should be something that will convince a senator or even a layperson to remove the official, and it should be convincing enough that it carries a consequence. Then the consequence that he or she will be further disqualified from having future office. I remember also the standard mentioned by Bernas on his impeachment primer. Since it is a political exercise, the standard is his gut feel. So it is the gut feel of the senators that is required. And while I know that isn't a lot, and we cannot quantify that, it goes back to the process being a political exercise.
Thank you, Congresswoman Zamora. We do have just one last prepared question before I think we can go to an open forum, and I hope the first panelists can join us again for that. The last question is, should the public be able to influence the trial as a political exercise? And if so, to what extent? And for the non-lawyers, those who are outside of law, generally, if it were a court proceeding and to a certain extent even an administrative proceeding, we really don't want the public to weigh in on how a judge or an administrative judge would rule on a particular case or complaint. But I think both speakers recognize, the earlier panel recognizes that impeachment isn't really a strictly legal proceeding. It's a mix at the very least of a legal and a political proceeding. So in your opinion, right, should the public be able to influence the trial as a political exercise? Vice President Duterte is a popular figure as much as the perceived people who are against her also have their own base of support. So your thoughts, please.
I think it shouldn't be a question whether the public should be able to discuss or talk about the impeachment process, but the question really is whether or should the public be able to influence? So meaning there's some level of exertion, of influence. By how? Probably by information that are circulated in social media, the mainstream media, etc., etc. In Professor Black's opinion, what the public should do in cases of impeachment really is to do what he refers to as vigilant waiting. And I agree to some extent that even as we allow the public to speak on matters that affect, their interest or the accountability of our public officers on some alleged and purported wrongdoings, I believe that it would be better that there has to be some balance. Now, whether the public should be able to influence how eventually the senators would have to decide on the impeachment case, I think that's another matter. But one other thing, and to my mind, this is what's more important, that this forum, our fellow lawyers, and of course our law students would probably be able to help in terms of elevating the quality of public discussion. And this is because it's important that even as we encourage our people to speak on matters of national concern, we should be able to help them sift through and navigate through the facts and be able to separate facts from fiction, and to be able to assess evidence-based assertions over mere propaganda or rhetoric or grandstanding.
Thank you, Attorney Season. Congresswoman Zamora.
I think what the Attorney Season said is actually very good. In fact, that we should really elevate the discourse, the level of discourse as regards impeachment. I guess for both sides, there are many things that are circulating, and we have to keep it to what we have as facts only. I think being a political exercise, of course, the public will always influence. In fact, if the question is, should the public influence? Yes, but maybe to a certain extent, maybe we should limit it to what is within the bounds of law, what is proper, maybe what is fair, and I think that we should allow both sides to also be able to present their evidence properly, completely in trial. And I know that for the senator judges, there will always be political considerations, even if we have our evidence. Both sides would have their evidence. The political considerations will always come into play. So that's my take on that.
Thank you very much. A round of applause for our panelists. We did allocate a few minutes for an open forum, so if I can bother our speakers of the first panel to join us again on stage to hear questions from our audience, both here and on live stream. Thank you. Thank you, and I do apologize for bothering you a second time. Thank you very much for joining us again on stage.
We'll begin with, so we have questions from the live stream, but I would like to ask first those who joined us in UPBGC, would you have any questions that you would like to ask? Please approach either mic on side. We'd be very grateful if you can introduce yourself and if you can let us know to whom in particular you would like to address the question, since it's quite a big panel.
Good afternoon. I'm CJ Narvasa. I'd like to ask Professor Te. Earlier, you opined that you would prefer that the rules of evidence, particularly the rules of evidence, not be followed or strictly followed in the proceedings. However, the rules of evidence were formulated with rights in mind. For example, what you were saying, the hearsay rule. The hearsay connected to the due process rights of an accused, in this case, a respondent. So if we do not follow the hearsay rule and a person is presented there who does not have personal knowledge of the signature of a certain document or has not personal knowledge, how then, first, can we trust that person? And second, how then would you uphold the primordial constitutional rights and human rights of due process and other constitutional and human rights that those rules were drafted and created to uphold?
Yeah, thank you for that question. First, I'd like to say that, as pointed out by Senator Drilon, should the Senate, in drafting its rules on impeachment, make the rules on evidence suppletorily applicable, then yes, the rules will apply. My point really was that we should not over-judicialize the proceedings, insisting on a strict application of the rules on evidence to the point of excluding what should otherwise be relevant to an inquiry into the sole issue of whether the public official should continue in office or not. Now, that formulation of the issue also addresses the question of whether rights are at the heart of the application of the rules. While I agree with you that the rules on evidence are intended really to protect rights, particularly due process rights in court proceedings. But again, and I guess we will go back to this over and over again, the impeachment proceedings are not court proceedings. The public official who is impeached is not an accused in the sense of a criminal case. And therefore, the rights of the accused are not implicated here. In fact, that may even be an open question. For example, self-incrimination, right? Could that actually be invoked in relation to, a question of a senator judge, right? Should, for example, the public official voluntarily appear and give testimony? And should the senator judge ask a question of the public official where the answer of the public official may tend to incriminate him or himself or herself, could the public official actually invoke the right against self-incrimination in an impeachment trial? I think that was the only point I was making, that we should not over-judicialize, because what I'm looking at in terms of the impeachment inquiry is really the fitness of the impeached official to continue serving, considering the gravity of the offenses that are levied against that official, and should they be proven true. Now, again, we do not have a constitutional presumption of innocence, as it were, in that particular proceeding, because it is not a criminal case. And therefore, we go back to how the Senate would formulate its rules, how the Senate would incorporate, for example, the rights of the accused, as it were. Should the Senate say in its rules, and I post this in the speculative because we don't have a copy of the rules yet, the Senate has not come up with its rules, should the Senate say the rights of the accused in criminal trials are applicable, right? And therefore, should the senator judge pose a question that may tend to incriminate the impeached public official, then the impeached public official can say, I refuse to answer on the ground that it will incriminate me. And the senator judge could not be able to ask that question. But again, I do appreciate the question because, yes, I agree. The rules and evidence are there to give us that protection. And I would be the last person to say that we forego those protections. But again, I stress that the impeachment trial is not an ordinary trial. It's not a criminal trial. It's not a civil trial. It's not even an administrative trial. It's sui generis. It is of its own class. And therefore, there is a huge discretion on the part of the Senate to craft those rules. The burden, the responsibility, I think, right, is on the Senate. And I'm hoping that the Senate will be able to come up with a set of rules that will really address questions like those, right? But thank you. Thank you for your question.
Thank you, Professor Te. Any other questions from the audience? We do have, while waiting for anyone to ask here, we do have one question from the online panel. And I think it was, spurred by the remarks of Attorney Season. So I think the question is, given the fact that public office is a public trust, how do we weigh the personal consequences to the impeached official against the public benefit of impeachment? And I think, just to add a little more complexity to that question, we've been talking about the whole afternoon on standards of clarity of evidence and the others. When in doubt, right? How do we weigh? Is it the potential public benefit or the potential public harm on the public officer?
I think there's really no contradiction in the two. It does not mean that when you try to protect the personal rights of the person under scrutiny in an impeachment case, it necessarily, or in our case, if we are the counsel or represent the vice president, it does not mean that the work that we will do in defending her or putting up the best defense available for her, as we are mandated to do under our legal ethics, it does not necessarily mean that we are in effect thwarting the public benefit that would come out of the trial. I guess what I'm saying is, for as long as the legitimacy of the impeachment process is clear and that there has been no infringement of any constitutional rights and that constitutionally imposed standards are complied with, then it does not really matter who you represent, whether you're for the prosecution or the defense, or whether the question of there was some public benefit that was derived from the entire impeachment process. I think the public benefit question would even be subject to what it is really that came out of the trial that we could consider to be a public benefit, if at all.
Thank you very much. Other questions from the audience? Yes, please. Kindly introduce your name and let us know to whom you're directing the question.
Sa lahat po, Romeo Maglunsod po, from MTC Alliance, BTS Party List. Ang tanong ko lang po, kung magkaroon ng impeachment trial, at ang sabi ng prosecution, evident naman na maganda yung kompleto naman ebidensya nila, at ang bansa natin ay magkagulo-gulo dahil nga merong malaking paksyon ng Duterte, malaking paksyon ng Marcos, malaking paksyon din yung ayaw sa kanilang dalawa. Ano ngayon ang mapapala ng taong bayan kung sakaling matanggal natin ang Vice Presidente sa pamamagitan ng impeachment trial? At kung sakaling mag-resign naman ng Vice Presidente, mauulit lang ba uli yung nangyari sa impeachment trial ni Pangulong Erap na nakatakbo uli siya naging mayor pa uli ng Manila, at parang wala ring nangyari, sabi nga ni Justice Morales, ituro daw sa electorate, ituro sa mga botante. Parang nangyayari sa impeachment trial, wala rin kaming napapala eh. After ng impeachment, makakatakbuli yung ipinapa-impeach natin. Hindi ba tayo nagsasayang lang tayo ng pera ng taong bayan?
Thank you po. So, anyone from our panel who would wish to answer the question? If I can kindly nominate Prof. Gwen. It's a very difficult question. I think that goes into there's a larger discourse now about how, compared to the Corona and the Estrada impeachments, where you basically have two sides, right? This one involves a more fractured society where there are many different political sides involved this time. So, is it really just a waste of time? If I can rephrase that question.
So, thank you for having been voluntold. The tables have turned. I have been called for recitation. No, but seriously. Siguro po, hindi naman sa nagpapasa ako ng voluntold kasi magbibigay naman po ako ng susubukan ko pong sagutin yung inyong tanong dahil mahalaga po yung inyong tanong, no? Pero baka maaari po din nating ayayahan mamaya si Congress Representative Zamora, no? Dahil sila po ang naghain, no, nung impeachment complaint, at nabanggit din po niya kanina kung bakit niya tinanggap yung paanyaya sa kanya maging miyembro ng prosecution panel. So makikita po natin doon yung kahalagahan nung impeachment process. Pero subukan ko po kayong sagutin. Hindi ko po mababanggit na bata pa po ako nung mga nangyari yung mga unang impeachment. So nasubaybayan ko po yung parehong impeachment, no? Yung impeachment ni Pangulong Estrada at yung impeachment din po ni Chief Justice Corona. Masasabi ko po na lalo na po nung impeachment at impeachment trial ni President Estrada, highly politicized po yung buong proseso na yun, no? Umabot nga po tayo nung pinag-uusapan natin kanina, isa pong kadahilanan kung bakit hindi natuloy yung kanyang impeachment trial dahil nung ayaw buksaan yung envelope, no? Nag-walk out din po yung ating prosecution panel. No? At matapos po nun, dahil din po dun sa ayaw na pagbukas ng envelope, nagkaroon po tayo ng EDSA 2. At matapos po ng mga pangyayari na yon, si Pangulong Estrada ay lumisan po mula sa Malacanang. At ang sabi nga po ng Korte Suprema, siya po ay nagbitiw, no? Nagbitiw sa pagkapangulo. Dun sa kanyang pagkakaalis sa Malacanang. So, sa kabila po ng mga pangyayari, no, nung panahon na yon, nasubukan din naman po nating tingnan kung hanggang saan natin mapapatakbo yung impeachment trial. No? At nabigyan po ng pagkakataon, hindi lang naman po yung prosecution panel at yung senator judges at yung defense team na subukang ipaliwanag sa taong bayan na nagmamatsyag po noon, no, nung first impeachment at yung pangalawang impeachment sa mga pangyayari. Pareho pong impeachment na yon, gaya po ngayon, naanyayahan din po ang UP College of Law at yung mga profesor na tumulong na ipaliwanag yung mga kaganapan nung parehong impeachment proceedings na yon. So, sa usapin po kasi natin ngayon, parang hinuhusgahan natin ang benepisyo at kahalagahan ng impeachment proceedings. Depende po kung ano ang kanyang magiging resulta. No? Kung natanggal, kung binawian ng kakayanan na tumakbo pa at maglingkod sa bayan na hindi nga po natin nagawa noong panahon ni Pangulong Estrada. Sa aking palagay po, ang kahalagahan nitong proseso na to, dahil ito ay ilagay natin sa saligang batas, ay ang kakayanan ng mababang kapulungan at ang Senado at maging ang Korte Suprema, no, dahil nakita po natin ang partisipasyon ng Korte Suprema sa paglalabas ng mga desisyon, no, lalo na po nung kapanahunan ng impeachment ni Chief Justice Estrada, ang mapalawig ang pagtunawa natin, no? Hindi lamang sa nilalaman ng saligang batas, kung hindi ang buhay politika sa Pilipinas. Kasi ito po yung isang pinanghahawakan natin, no? Na maaari natin, lagi natin binabanggit dito, public accountability. Okay? Na maaari po nating singilin sa mga hinalal natin, no? Sa mga na-appoint sa posisyon na kailangan inyong ipakita, no? Ang hindi lang kakayanan, kundi na kayo ay karapat-dapat na patuloy magpatuloy sa inyong posisyon at maglingkod sa bayan. So napakahalaga po nung inilagay natin itong proseso na to sa ligang batas at ipinapatupad po natin ito. So nandun po sa akin yung, maaari po hindi natin nakikita agad yung benepisyo dahil sa isip natin, ang benepisyo nitong proseso na to, matanggal yung opisyal at hindi na siya mabigyan ng pagkakataon na mahalal, no? O mabigyan pa ng posisyon sa gobyerno. Pero sa akin, may kahalagahan yung proseso kung talagang nabanggit nga ni attorney kanina, no, yung vigilant waiting. Na bukod sa Senado, bukod sa mababang kapulungan, bukod sa Korte Suprema, tayo mismo, no, magmatsyag ng mabuti. Gaya nga po nung nangyari nung kay President Estrada, na napag-usapan natin ngayon yon. Sinabi na siya ay nag-resign. Ang sinasabi po ng mga panelists natin kanina, may kakayahan ang Senado noon at may kakayahan siya ngayon na kung nais ipagpatuloy upang siya ay hindi na po mahalal muli. Dahil magkakaroon na tinatawag natin perpetual disqualification, maaari po sana isinulong yon kahit noon po man. Pero ngayon na alam na po natin yun, alam po natin na yun ang resulta na ayaw na nating mangyari, naipaabot na po siguro natin sa Senado ngayon ang ating pag-iisip sa bagay na yun, ano? Sa bandang yun, na may kakayanan ipagpatuloy ang impeachment trial upang makapagpasya ang Senado, kahit na nag-resign na po, bumitiw na po ang opisyal, may kakayanan magpasya ang Senado na sabihin hindi na siya maaaring mahalal pa muli o mabigyan ng pagkakataon na magkaroon pa ng posisyon sa pamahalaan.
Thank you.
Sana po nakatulong yung sagot po.
I think Congresswoman Zamora, if you wanted to respond, and then Commissioner Sarmiento, I think also wants to respond. And then I think, for lack of time, we'd have to end the forum on this question.
Thank you po. So without going to the merits or to the evidence, it is our duty as representatives, as members of Congress, to file this impeachment complaint because we saw grounds to support the articles that we have. Gaya po ng sinabi ni Professor De Vera, kailangan nga po natin na mailabas sa taong bayan yung ebidensya. Hindi po siya waste of time, hindi po siya waste of resources, because there is separate consequence of disqualification from holding another public office or any public office in the future. Hindi po nagtatapos sa resignation ng isang impeached or impeachable official. Pwede pong ipagpatuloy ng Senado ang trial para malaman natin kung dapat nga bang ma-disqualify yung official from holding public office. So kami naman po sa Kongreso, may nakita kaming ebidensya, kaya po kami nagsampa ng complaint for impeachment.
Commissioner Sarmiento?
Tatlo po ang pakinabang na nakikita ko po sa usaping ito ng impeachment. Una-una, serves as a political education sa ating taong bayan. Natatandaan ko po doon sa Estrada proceeding, ako po ay komentarista ng Channel 5 every after trial, every session, at marami pong interesado. As a matter of fact, a survey was conducted that because of these impeachment proceedings, maraming gusto tumaas ang enrollment ng mga kolehiyo because of these impeachment proceedings. Natuto sa proseso. Pangalawa, yayaman ng ating jurisprudence kung ito po ay masagot ng ating Korte Suprema. Yayaman ang ating pagkaintindi ng constitutional processes. For instance, dalawa ng sinampa. Baka may susunod pa. That will enrich jurisprudence for the sake of our future law students and future generations. Pangatlo po, it will serve as a deterrence, no, sa mga gustong tumakbo, manungkulan. It's a warning na pag kayo ay hindi gumawa, hindi maglingkod sa taong bayan, ito ang consequence na posibleng mangyari. So para sa akin po, this exercise is a fruitful exercise for all of us. Estudyante, magulang, lahat ng sektor ng ating lipunan.
Thank you, Commissioner Sarmiento. So sa dami ho ng tanong na ilabas today, yun po ang pinakamahirap. Salamat po na nasagutan po ng ating mga panelists. Thank you again to our esteemed panelists and speakers for today. Can we please give them one last round of applause? So, as our panelists go down the stage, I would just like to, and before we call on our Chair of the Malcolm Foundation for his closing remarks, we would just like to thank the UP College of Law Office of the Dean, the Malcolm Foundation, the Philippine Law Journal, certain offices in the UP Law Complex, such as the Information and Publication Division, ICTO, and the UP BGC administrative staff, Ms. Cristel May Parungao, my research assistants, Nick Castro of the class of 2025, Jill Chua, Jules Espino, R.D. Mercado of the class of 2026, and Block 1 BGC Day 2, who served as our ushers today for helping us organize this program. We have two brief announcements before Justice Carpio gives his closing remarks. The first is that the transcripts of today's proceedings will be made available by the Philippine Law Journal in its new website. You may visit philippinelawjournal.org in a few days in order to see the transcript. The second is that coming from the preparation by the UP College of Law of a primer on impeachment and frequently asked questions. We have heeded the instructions of our dean and the request of the public to prepare translations of the impeachment primer and frequently asked questions, which will be made available in the UP Law website later this week. They will include a Filipino or Tagalog translation, an Ilocano translation, and a Cebuano translation for the general public. So please stay tuned for that. It is my honor to call on the chair of the Malcolm Foundation and former Senior Associate Justice Antonio T. Carpio to give his closing remarks and to end today's program.
I think he just arrived from a different engagement, so he kindly asked me if I could. And the interpretation of a former clerk in Justice Carpio's office and a colleague for the longest time is that that was not a request. So thank you.
that put the Constitution at the center of the national conversation. And in our nation's history, other than revolutions, perhaps it's impeachment that often takes over the national consciousness once it happens. We moved fast to hold this first forum because in the age of disinformation, it would be unfortunate for inaccuracies to dominate the conversation. Our hope for these events is to provide a venue for studied and measured argumentation, not a Twitter war, not a troll fight. Because what is unfolding is the greatest of proceedings involving a constitutionally elected official. We are thankful for the quality and quantity of participation today. We have a packed auditorium, an overflowing online registration, and partnerships to broadcast and live stream this nationwide. Days like these are a good measure of good citizenry. We are also thankful, of course, for Professor Paulo Tamase and his conscripted labor force, his students. They put this together practically over the weekend. We in the Malcolm Foundation are spoiled with this good work. And of course, we are thankful for the full support of Dean Lelen Berberabe, whose guidance in all of these events have proven invaluable. We look forward to more events like this because with the filing of the third petition in the Supreme Court regarding impeachment, it is safe to say, parating pa lang tayo sa exciting part. Kasi as I was telling two panelists earlier, maybe the next topic should be, we keep on hearing impeachment is political. Ano ba ibig sabihin ng political? So yes, simula pa lang to. At paulit-ulit po tayong magkikita at mag-uusap, magpapalit ng pananaw at makikisalimuha sa isa't isa. Dahil hindi po ba ito ang sentro ng masiglang demokrasya. At pagdating sa impeachment, maaring senador ang boboto, pero di natin makakaila. Bayan ang humuhusga sa ating lahat. Maraming salamat po.
Thank you, Professor Molo. That ends our impeachment forum for this afternoon. Thank you for joining us here in UPBGC and in our live streaming channels. For our speakers, maybe request that you just come up here below the stage for a brief group photo. Our speakers and special guests, as well as the faculty, are also invited to room 404 after we leave the venue. Thank you very much and good afternoon.